If you have a green card and you're planning international travel, a brand new Supreme Court ruling just changed the rules for anyone who's ever had a brush with the criminal justice system, even an arrest that never led to a conviction. This isn't about losing your green card at the airport, but it could mean the difference between walking through customs as a resident or getting pulled into a review that puts the burden of proof on you. In this video, I'm breaking down exactly what the court decided, the three separate re-entry risks every green card holder should know about, and what to check before you ever book that flight. If you have a U.S. green card, intend to travel overseas, and have ever dealt with a criminal case, a recent Supreme Court ruling may change how you are handled on return. It explains when officers may treat some returning residents as applicants for admission before the full criminal question is resolved, but it does not cancel green cards, create automatic refusals, or place every permanent resident at the same risk. As of July 24, 2026, the Supreme Court has issued a final decision on the narrow legal issue in Blanch versus Lau. Lau's personal case was sent back for more proceedings, so his case is not finished yet. In this video, we will explain what the court actually decided and three separate re-entry risks: criminal-related issues, long or repeated absences, and immigration court or travel document problems too. Only the first risk is directly tied to the new ruling. The other two are existing rules that still matter in 2026. Our goal is to explain serious changes without causing panic. So let us start with the usual rule. A lawful permanent resident returning from a temporary trip abroad is usually treated as already admitted to the United States. In most cases, the person does not need to apply for admission again. However, federal law lists several exceptions. If one exception applies, the government may treat the returning resident as an applicant for admission. That legal label matters. An applicant for admission may be reviewed under the grounds of inadmissibility. In simple terms, the government may examine whether a legal reason blocks admission. This is different from deciding whether someone already admitted is deportable. Now, let us look at the Supreme Court case. Mukcho Lawo became a lawful permanent resident in 2007. In 2012, New Jersey charged him with trademark counterfeiting. While that criminal charge was still pending, he traveled to China. When he returned through John F. Kennedy International Airport, a border officer did not formally admit him. Instead, the government paroled him into the country while the criminal case continued. Immigration parole does not mean parole from prison. It means the government allowed him to enter the country physically without making a final legal admission. At that time, Lau later pleaded guilty. The government began removal proceedings and argued that he was inadmissible because of a conviction for a crime involving moral turpitude. This legal category can include some fraud, theft, or other dishonest offenses. The exact answer depends on the criminal law, required intent, court record, and any exception. A charge name alone does not decide the immigration result. A federal appeals court said the government needed clear and convincing evidence at the airport that Lawo had committed the offense before treating him as an applicant for admission initially. Clear and convincing evidence is a high level of proof. On June 23, 2026, and the Supreme Court rejected that rule in a 6-3 decision. The court held that the Immigration and Nationality Act does not require a border officer to have clear and convincing evidence before treating a returning permanent resident as an applicant for admission under this crime-related exception. The court described two steps. First, the government decides whether the resident may be treated as seeking admission because the person committed a listed offense. Later, it must establish a legal ground of inadmissibility for the category in Lau's case, which generally requires a conviction or a valid admission of the offense itself. There is an important limit. The Supreme Court did not say that every arrest proves a crime. It did not say that every pending charge makes a green card holder inadmissible. It did not say that a person will automatically be denied entry. The court also did not announce one exact minimum amount of evidence that officers must have in every future case. It decided only that the high, clear, and convincing standard does not have to be met at the airport. The court also did not decide whether Lau's trademark counterfeiting conviction was actually a crime involving moral turpitude. It sent that issue back for more review. Because the Supreme Court interpreted federal immigration law, its narrow holding applies nationwide to similar cases now. But it is not a new travel ban, and it does not rewrite every green card travel rule. Now let us separate who may be affected. The ruling matters most for a green card holder with a pending charge, guilty plea, conviction, unresolved arrest record, or incomplete court papers involving a listed offense. It may also matter when someone does not know how an old case ended. A green card holder with no criminal issue, a temporary trip, strong ties to the United States, and proper return documents is not the direct focus of this decision. Nationality is not the main factor. The exact criminal law, the court record, the travel history, and the immigration rule matter more overall. Now we can look at the first major re-entry risk. The first risk is traveling with a criminal issue that has not been reviewed for immigration effects. Many people assume that no conviction means no travel risk. Laos' case shows why that assumption can be unsafe. A pending charge may lead a border officer to examine whether the crime-related exception applies. The officer does not have to satisfy the rejected clear and convincing standard at the airport before that process begins. But a pending charge is not automatic proof that the person committed a qualifying offense. An arrest is not the same as a conviction. A dismissed case is not the same as a guilty plea. Whether the exception applies still depends on the facts, the law, and the evidence. Consider a clearly hypothetical example. Maria has held a green card for 11 years. She faces a pending fraud-related charge, but her criminal case still has not ended yet. A friend tells her travel is safe because she has not been convicted. Maria leaves for an important family event. When she returns, Customs and Border Protection sees the pending case and sends her to secondary inspection. Secondary inspection means additional review. It does not by itself mean that Maria has lost her green card or that she will automatically be denied entry. However, officers may ask about the charge, review records, or decide that a later legal process is needed. In some cases, a traveler may be paroled rather than formally admitted while the issue is addressed. The confirmed point is narrow. The rejected high-proof standard is not required at the airport. The exact evidence needed in every future situation remains uncertain. The court did not hold that an accusation alone automatically proves commission of a qualifying crime before anyone travels. Anyone with an arrest, charge, plea, diversion program, probation, conviction, or sealed case should obtain the complete court record. A qualified immigration lawyer who understands criminal immigration law can review the exact statute and documents before departure. Do not rely only on the offense name, a friend's advice, or a social media clip. Do not hide an arrest or give a false answer to an officer. False information can create a separate and more serious immigration problem. The second risk is different, and it existed long before the Supreme Court decision. It involves long or repeated travel outside the United States. There are 3 time rules that people often mix together. First, a continuous absence of more than 180 days is one of the legal exceptions that can cause a returning green card holder to be treated as an applicant for admission. Crossing that line does not automatically cancel the green card. It changes the legal position of the traveler at the border and may lead to a broader admission review. Second, abandonment can become an issue even before 1 year. Abandonment means the government believes the person no longer intended the United States to remain their permanent home. Officers and immigration agencies may examine the full pattern, including the length and purpose of trips, work, family, housing, taxes, and other ties to the United States. One short visit to the United States each year does not automatically preserve permanent resident status if the full record shows that the person is actually living abroad full-time. Imagine another hypothetical example. David works from another country for 5 months, returns to the United States for 3 weeks, and then leaves for another 5 months. He believes there can be no problem because neither trip is longer than 6 months. But the government may look at the whole pattern and ask where David truly lives. His short returns do not automatically prove that the United States remained his main home. Before I walk you through the third risk involving immigration court and travel documents, if you're finding this useful, go ahead and subscribe so you catch these breakdowns as soon as they drop. Third, the 1-year mark can create a separate travel document problem. A permanent resident who remains outside the United States for more than 1 year, or beyond the validity of a re-entry permit, generally cannot rely on the green card alone to return and resume permanent residence. In some cases, the person may seek a returning resident visa called an SB1 visa. That process usually requires proof that the trip was meant to be temporary and that the extended stay happened from circumstances beyond the person's control. A re-entry permit can help with a planned long trip, but it must be requested while the person is physically inside the United States. It is generally valid for up to 2 years, although some permits have shorter validity periods instead. It cannot be extended. A valid re-entry permit can protect against a finding of abandonment based only on the length of the absence while the permit stays valid. It does not guarantee admission, it does not erase a criminal issue, it does not stop removal proceedings. Other facts may still matter. Long travel can also affect a future citizenship application. An absence of more than 6 months but less than 1 year can create a presumption that continuous residence was broken, although the applicant may overcome that presumption with evidence in some cases. An absence of 1 year or more normally breaks continuous residence unless a limited legal exception applies. This citizenship issue is separate from whether the person still has a green card, but it matters before travel. Write down every departure and return date. Review the full pattern, not only the next trip. Keep honest proof that the United States remains your permanent home, such as tax returns, work or school records, housing records, family ties, insurance, and other ordinary evidence of daily life here. Do not create fake records. If you expect a long absence, review the re-entry permit rules before leaving soon. The third risk is less obvious. It involves an active immigration court matter or a problem with the documents needed to return. Federal law includes another exception for a permanent resident who leaves while under a legal process seeking removal or extradition abroad. That means a person in formal removal proceedings may face a different legal position when returning from international travel. A notice to appear, often called an NTA, is the charging document used in a removal case. Receiving the paper and having a court case are related, but they are not exactly the same event. Formal immigration court proceedings begin when the Department of Homeland Security files the NTA with Immigration Court after first serving it on the person. A pending green card renewal, citizenship application, or family petition is not automatically a removal proceeding. The important question is whether a formal case was filed in immigration court, whether an immigration judge issued an order, or whether an old case remains unresolved. Consider a hypothetical resident named Omar. Years ago, he received papers after an immigration inspection, then moved without understanding whether a court case had started. Before booking a trip, he checks the record and learns that an old matter may still need attention. Finding it before departure gives him time to seek qualified help. Travel documents create another part of this risk. A valid green card is the normal return document for a temporary trip. In some situations, an expired card may be used with a valid USCIS extension notice. A temporary ADIT stamp may also serve as proof of permanent resident status. If a green card is lost, stolen, or destroyed while the resident is outside the United States for less than 1 year, Form 131A may be available to request carrier documentation. If a valid re-entry permit is lost, stolen, or destroyed while the resident is outside the country for less than 2 years, Form 131A may also be available depending on the permit and the facts. Carrier documentation may help an airline transport the person to a U.S. port of entry. It does not decide whether the person is admissible. Customs and Border Protection makes that decision during inspection. Check your passport, green card, extension notice, re-entry permit, and court papers before departure. If you ever received an NTA hearing notice, parole paper, or removal order, confirm the current case status. Online tools can help, but official court notices control at the border ultimately. Answer questions truthfully and remain calm. Further inspection alone does not mean your status is gone. Keep every document you receive and note whether you were formally admitted, paroled, asked to return for deferred inspection, or given immigration court papers. Do not sign a document you do not understand. Form I-407 is used to record the voluntary abandonment of lawful permanent resident status. Signing it can have major consequences. Ask what any document means and seek qualified legal help when possible before making a decision you do not understand. We also want to correct 3 rumors that can cause unnecessary fear. The first rumor says the Supreme Court allowed border officers to cancel any green card at the airport. That is false. The decision answered a specific evidence question under a crime-related exception. It did not create automatic loss of status for all returning residents. The second rumor says any arrest now guarantees denial of reentry. That is also false. An arrest or pending charge does not automatically prove a qualifying crime, and it does not automatically make a person inadmissible. It may lead to closer review, which is why the exact record should be checked before travel. The third rumor says a trip over 6 months automatically cancels a green card, while a reentry permit guarantees safe return for 2 years. Both statements are misleading. More than 180 continuous days can change how a resident is treated at the border, but it is not automatic cancellation. A reentry permit is useful protection, but it does not guarantee admission or solve unrelated criminal or court issues. The balanced message is simple. Do not panic, but do not assume that a green card makes every international trip risk-free. Most permanent residents with no criminal issue, a temporary trip, strong U.S. ties, and return documents are not the focus of Blanch versus Lau. The people who should be most careful are those with a pending charge, old conviction, incomplete criminal record, long or repeated absence, weak U.S. residence ties, missing return documents, or immigration court history. Early planning cannot promise a result, but it can help prevent avoidable mistakes. This information reflects official materials available as of July 24, 2026. Immigration rules and court interpretations can change. This video provides general education and is not personal legal advice. Every case has different facts. Anyone facing an arrest, criminal record, removal case, official deadline, long absence, or serious travel concern should speak with a qualified immigration lawyer or an accredited representative. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming next.